Good morning, sir. I'll turn my camera off till 9:30. Nice to see you.
Nice to see you too. At least we can all get in there. So
Yeah.
we're just waiting for Mr. Fraser Urquhart, and I think we're all there. But we'll see. Hopefully Nikki will come online at some point and just ensure that everybody's here. But if not, I'll put my camera on about 9:28.
Great. See you in a
Thank you.
minute then. Thank you.
Morning, sir. How
How are you?
I'm fine. Are you getting a echo? Because I'm in the same room as the screen. So
Not too much. You're slightly broken up, but nothing that I can't live with. When I heard Mr. White, he was absolutely fine.
I'm just going to turn off because it's also coming through the screens in here. So I think I'm going to turn the audio off here and just make sure. Oh, actually, that might affect the streaming. That's the only thing. Okay. Well, I don't need to speak. You can't hear any feedback your end?
No.
And I'll be on mute anyway in this room, so that's fine. Okay.
And I sound okay, do I?
You do. Yeah. And Mr. White sounded very clear as well. So
Okay, for
hopefully
some reason, I
hopefully
don't
all
know if I
well.
can turn my camera off, but it doesn't seem to be the camera one. The microphone is, but never mind. I'm here anyway.
Okay. No, that's good. All right.
Good.
Thank
Is
you.
the only thing I just suggested yesterday for Dan to be online. I really doubt it that we're going to need Dan, to be honest. But just in case.
Yeah, I think we've invited Dan and Sarah Butterfield and Richard Wood and Alan Munn were
Richard.
there as
Yep,
well in the
that's
background.
fine.
So
That's
yeah.
fine. I can't see that we'll need them because I think what I've got.
Okay.
We've got the appellant's response today. So I'll go through some ID numbers this morning so Dan can make a note of those. But beyond that, everything's sorted, everything's up to speed. The site visit went very well.
Good.
We
Good.
went with the fishing club representatives. We had a full walk around the lake. I think they recognise now the limitations to what this application means for the fishing club. But at least we had a chat about their frustrations and where they can perhaps discuss some of the maintenance issues in a different forum to the planning inquiry.
Okay.
So I think we come away fairly happy from that
I
anyway.
think this is we're actually streaming because I can't stop. So but yeah, that's good.
No, so the site visit, we saw everything we needed to see yesterday.
Good.
And fortunately the weather held, so it was a good walk. But yeah, everything we saw we needed to see, we completed in their entirety. So the site visit was complete yesterday.
Good. Okay. All right.
All right. I can't, as I say, I can't turn my camera off. There's a camera emblem on mine. I've got a stop video sign, which I'm thinking, oh, I don't want to touch that one because I'm not familiar with Zoom.
What I do need to do is I need to log on to YouTube and just see how it's coming through there. So I'll do that now as
Okay, so I'm going to leave my
well.
camera. I'll have to leave my camera on. I dare
Okay.
not turn it off, but
All
I'll
right.
mute. I'll be doing some things.
Okay, I'll turn my
We'll see you
camera
at
off
about
now.
9:28.
All right. Thank you. Bye.
Good morning, sir. Can I just check that you can see and hear me okay?
Yes,
All right, thank you.
and Mr. White's already been on, so I can see Mr. White as well, or I have been able to see Mr.
Ah,
White.
brilliant. Thank you, sir. See you shortly.
Well, good morning, everyone. It's now 9:30. The inquiry is now resumed. Could I please ask the advocates from the main parties to put their cameras on, please? I'm not seeing Mr. White nor Mr. Fraser Urquhart, nor do I have at this stage any closing submissions provided.
Well,
I can
sir,
see both of them, sir.
yes, I can see Mr. Fraser Urquhart. I can see you, so that's what why you're blind.
Right, I can't see Mr. Fraser Urquhart.
You're on mute, Andrew.
Thank you very much. I'm now unmuted. Can you hear me?
I can see you now. It looks
good
like
stuff.
your picture pops up when you speak, I think.
Can you see
Good.
me, sir, when I speak as well?
Yes, it's one of these, I think, where for whatever reason the technology is only giving me one at a time, but that's not necessarily a problem.
Well, so if you go top right and the view, you can press, if you go to the view and ask for it to be in gallery mode.
Ah, right. Got it. Yep, that's fine. We don't have Zoom at the Planning Inspectorate, so it's my first time of using Zoom, I'm afraid.
Is it? Gosh, okay.
All right.
Can
I just say, sir,
Teams. Anyway.
Did I
Right.
hear you say you haven't had my closings? I think they have been emailed to you, sir.
I've just sent an email to Tim, actually, just to ask him to chase him up. He's not sent them through as we speak. Oh, wait a minute, one's just come through. I have the appellant's closings. I'm just waiting for the other one now.
I don't think you do. You can't have our closing.
No, I'm not going to. I'm going to wait until.
Well, that's what I was going to ask, sir. We haven't expressly sent it through because what I was hoping to do, Mr. Fraser Urquhart has very kindly sent his through. I'm just going to add a few points. So when he's finished, if you just give me 10 minutes to send it through to Mr. Salter, then you don't have to use your pen, which I think would be convenient for you and frankly better. So if you wouldn't mind, and Mr. Fraser Urquhart's happy for that, I would just ask for that.
I have the councils. It's been the emails incorrectly says the title of the email says appellants, but when I've opened it, it's the councils. So we're on track.
That's probably my fault.
Mr. Fraser Urquhart, frankly, we could probably swap our respective positions in this inquiry.
All right, let's go through the formal things and have a little bit of housekeeping, and then we'll start. Okay. All right. I assume everyone can hear me because you've all interacted with me on the call. For the purpose of the live stream, my name is Stephen Normington. I've been appointed by the Secretary of State to hold this inquiry into an appeal made by Vulps Limited, trading as Vulps Land, Ashfield Land Developments Limited, and Davidson's Developments Limited. The application is for outline planning permission with access not reserved for up to 700 residential dwellings, areas of public open space, a rugby pitch, landscaping, allotment, sustainable drainage, and associated infrastructure. And the application is accompanied by an environmental statement. The appeal site's located on land to the west of Brackley. My role is to carefully consider the evidence provided in this inquiry and make a decision whether the appeal should be allowed or dismissed. No other housekeeping in terms of the building today, so Mr. Callis can relax. I'm not going to ask anything about fire alarms or anything of that nature today. A couple of housekeeping things just to run through before we start the closing submissions, and then I'll explain what's going to happen today. Completed the site visit in its entirety yesterday, so thank you to participants from both parties for that, and thank you for Mr. Callis for driving all of us round, so we stuck together throughout the site visit, and that was really helpful. So we saw everything that we needed to see yesterday. One piece of inquiry documents has been submitted this morning, which I assume Mr. Callis has tuned in today, which I'm going to call as ID 14, and that's the appellant's observations on the information provided regarding the statements of common ground. And that's the information provided by Mr. Wood yesterday that we recorded as ID 13. So I now have the appellant's response to that, which seems to be a fairly factual response, and I assume prepared by Mr. Tiley. Unless the advocates tell me otherwise, I think it is what it is. It's a position of the appellant in response to the information that Mr. Wood provided. And I'm not sure if we need to say anything further than that. It seems pretty straightforward and factual to me.
That was exactly the approach I was going to adopt.
Mr. Fraser-Urquhart, are you content with that?
Content with that, sir, yes.
Thank
So
you.
just
I have no other.
sorry. Before you move on from core documents, Mr. Callis, who's compiling the list for the website, just finds a slight uncertainty as to what ID 6 is. If you have your list in front of you, would you mind just reminding us?
ID 6 was the updated position on the Scott schedule sites.
Thank you, sir.
Sorry, sir. Just to clarify, it was actually ID 9. I think we're missing. Sorry.
ID 9 is a revised site visit itinerary.
Right, I did think it was, but thank you for clarifying.
Yeah, that's the one with the addition of the fishing lake included.
Yes, thank you.
So we should be up to date from ID 1 now to ID 14.
Yes, we are. Thank you, sir.
And as we move through today, the council's closing submissions will be ID 15, and the appellant's closing submissions will be ID 16. I'll reaffirm those, Mr. Callis, as we go through today in terms of the final little bits of housekeeping. So in terms of where we're at, that seems to me that everything up to this point now is up to date and complete. So today, or this morning, is entirely dedicated to closing submissions, firstly on behalf of the council, and secondly on behalf of the appellant. There'll be no interruptions, no questions by anyone during the course of those closing submissions, nor indeed afterwards. Once we've heard those closing submissions, as I mentioned, we'll start with the council first and then move on to the appellant. We will have a little chat about whether there's likely to be any cost applications. Once we've done that, we'll have a final chat about the housekeeping of some information that's still required to be submitted, and that primarily relates to planning conditions and the Section 106 agreement. I'll then explain what will happen next in terms of my procedures, and then we will close the inquiry to any further oral submissions. So I'm optimistic that that will take us to just before lunchtime. Are there any other aspects of housekeeping from either advocate that I need to be aware of beyond what I've said there?
Yes, there are. So just briefly, and maybe that Mr. White is intended to say the same thing as I am. Overnight, there was an exchange between the parties as to some authorities upon which they would rely. And Mr. White and Mazia very kindly provided me with an indication that they were going to refer to 3 cases. In those circumstances, I would reserve my right to reply on the matters of law that they raise. Having seen the authorities, I think such reply will be brief, but I'd rather obviously hear the point they develop from those cases before attempting to rely on that. And then that will be obviously subject to Mr. White's final right of reply, as he is the appellant. So just to make you aware that there's likely to be that little toing and froing at the end. For my part, I intend to refer to one authority which I've provided details of to my learned friends. So I think we all are ready to go on that front.
Okay, where do those authorities sit in relation to the core document list? Are the new inquiry documents that
yes,
not seen, or are they already in the core document list?
No, I think they're all new. All new.
So we're going to have to record those as inquiry documents.
Actually, I'm not sure. I think I know Wayne Holmes is E21. So can we get back to you on that, sir, rather than spending time? But I certainly intend to submit to PINS the authorities. So you'll probably might have duplicates, but you will certainly not leave here without the 4 authorities, the 3 we're referring to and the one my learned friend is referring to.
Exactly, so yes.
Okay, if depending where we are at the end of the day, I will give them core document numbers either orally this morning, or if not, in an email later today or on Monday, depending on when they come through to me. I'm not going to take much more time on that, but I'm aware that you're on a holiday, Mr. Fraser, and I'm just thinking about in terms of any response to those authorities. Not for now, but just have a think of when the appropriate time might be for you to be able to respond to those.
Oh no, I would intend to respond orally effectively as once Mr. White has finished his submissions.
That's helpful. Then I was expecting you to provide me something in writing, but if you're content with orally, I'm content with orally.
Having looked at the authorities overnight, obviously I don't quite know how the points will be developed from them, but I have a pretty broad indication of my own mind as to what my response will be. It will be brief, and therefore, I mean, frankly, in the circumstances, I'd rather not have to spend time reducing them to writing when they can be dealt with, very briefly at the end of these oral submissions.
Okay, if you're content with that, I'm content with that. I'll make a note. It's easier on the paperwork, and so if you can do that, tell me when you want me to make a note, and I will do so.
Yes, well, as I say, once Mr. White finishes, I'll have another very brief go, and then no doubt Mr. White will want to come back on what I've said in the same way.
Okay. Any other further bits of housekeeping beyond that?
So can I just deal with just very a couple of matters just to get confirmation? I don't know to what extent you picked up, but I do know, just to give you a sense, the deadlines you gave yesterday, that from the appellant's point of view, I know there's been contact with Mr. Callas and my learning friends instructing solicitor on the section 106. So there you'll see we will set out clearly where the position lies in closing. I think it is important to say we have reflected on the section 106, and in relation to allotments, we think there is a mechanism there to give you comfort. In relation to the rugby club, that I don't think there's an effective way of dealing with it, but for the reasons we'll address you in closing, we'll still say that you should give the weighting that Miss Butterfield did in her evidence, and that will be set out. But I just want to give you comfort that I think the deadlines of submission of those documents will occur in accordance with the timescale you set out yesterday.
No problem. I'll refresh that timescale because I did think about overnight, and I did think about I'll refresh that timescale at the end of today when we have that final little mop up of time. The timescale.
Yes. Now, so can I also say, due to certain arrangements that certain people have, I would love more than anything else in my professional career to make a very extensive and long-winded application for costs this afternoon, but I am not going to do that. There will be no applications from the appellants in this matter, sir.
Okay, I could bring that forward and ask you, if Mr. Fraser, if there's any application from the council.
No application from us, sir, either. So I'm grateful for my learned friend's indication, which I think I'd seen a hint of at least yesterday. So I'm grateful for that confirmation, and obviously that's a part of the process you won't need to trouble yourself with.
Yeah, and I'm grateful for that confirmation too, for obvious reasons. I don't have to trouble myself in writing a costs report. All right. So I think we're up to date. We'll do a final mop-up later. So we've dealt with the costs as we are. So I think I'll ask Ms. Fraser-Urquhart if you can perhaps come in and show our closing submissions to this inquiry, please.
Thank you very much, sir.
Before that happens, can I just make what? Are you content if I just keep my camera off, as I'm going to be thinking about what Mr. Fraser-Urquhart's saying? So could I leave the floor to my learned friend?
Yes, sir. I was going to say
Absolutely.
I find it rather distracting to watch other people reacting with wince or joy to my submissions, and therefore I'm more than happy for my learned friends and everyone except you and I, sir, to disappear.
That's absolutely fine.
It would be joy, Mr. Fraser-Urquhart. Thank you, sir.
Thank you very much. In which case, please come in when you're ready.
Thank you very much, sir. Do you now have the copy of my submissions in front of you?
I do. It's open up the side of you.
You will note that on page 1 in the introductory session, I set out, much as I did in opening, the nature of the application, the nature of the putative reason for refusal. I won't read those again, and I'll start, sir, if I may, with paragraph 4, where I note that a section 106 has now been entered into, and although there remains some, or at least it's been agreed, not yet formally entered into, and although there remains some toing, excuse me, I hope this isn't going to be a problem. Although there remains some toing and froing to be done, and my learned friend may have submissions on the weight to be given to various aspects of the 106, as far as the council is concerned, it is and was acceptable and therefore the reason for refusal does fall away, and our position is that planning permission ought to be granted. And again, I record the fact that the dispute is as to the route by which the planning permission should be granted. And I note again that we've heard from both planning experts, witnesses, that whichever route you take, planning permission ought to be granted, and that remains the fundamental underlying position at this inquiry. I will illustrate now, if I may, the council's position in that regard, and we contend that the development plan is not out of date, should continue to apply with full force, but notwithstanding that, we conclude that the benefits of the scheme outweigh the undoubted breach of development plan policy which the scheme represents, and therefore, even on a normal or flat planning balance, permission ought to be granted. That's common ground between the parties. You saw that, in fact, on a number of occasions in the oral evidence. And I'm not going to therefore make extensive submissions on the point, particularly as I imagine that Mr. White will want to emphasise the position in more detail in his closing submissions. The position, broadly speaking, was explained by Mr. Callis in his evidence. The spatial strategy of the development plan envisages that development will be brought forward in sustainable locations in accordance with a tiered hierarchy, in which Brackley sits below Northampton and Daventry. The appeal site's outside the settlement boundary of Brackley, in an area where the development of housing is strictly controlled. Accordingly, the development is in breach of the locational criteria of the development plan, particularly policy R1, which Mr. Callis took us to in his proof. However, the development is considered to be in a sustainable location, being immediately adjacent to the settlement boundary of Brackley, and it brings with it significant benefits: delivery of market and affordable housing, improved public transport, walking and cycling links, land for a new rugby pitch for Brackley Rugby Union Football Club, the provision of allotments, public open space, designated play areas, biodiversity net gains, and contributions to the economy, all benefits which we say are significant. The environmental and other impacts of the scheme have been assessed. They're limited and none are sufficient to justify refusal. And therefore, notwithstanding the breach of the locational criteria in the development plan, we submit that the planning balance, when applied on a flat basis, indicates that planning permission ought to be granted. And you'll recall, of course, that Miss Butterfield, entirely unsurprisingly, agreed with that position when I put it to her in cross-examination. We now turn, though, to the appellant's position, as they assert that the policies of the development plan are out of date, and accordingly the tilted planning balance in 11D applies, such that planning permission ought to be granted unless the harm caused by the scheme significantly and demonstrably outweighs the benefits. We disagree, as you know, with this. Now, the appellants most succinctly put their case in opening, which I've quoted directly from Malone and Friends, paragraph 25. And I note there the appellant's case is that the development plan is out of date and the tilted balance is engaged. And I set those out for you. You've seen them. I won't read them. I'm going to deal in turn with each of those reasons. Now, it's convenient, first of all, to deal with whether the council has a 5-year housing land supply, because obviously we accept that if we can't demonstrate such a supply, by the automatic operation of footnote 8, the tilted balance will automatically apply. I think I used the phrase "game over" in the oral examination. Now, so you've had the benefit of extensive comment on individual sites during the round table session, and as we foreshadowed, it's not intended in these submissions to provide detailed commentary on each site. And instead, I'm going to confine myself to dealing with the issue of the appropriate area for assessment. And thereafter, I make some discrete points of general application to the consideration of the individual sites. I'm sure that's acceptable. Now, turning to the area of assessment, the appellants suggest that housing land supply should still be calculated with respect to the previously existing area based upon the 3 authorities which are now combined. However, this is a very self-serving position which is neither logical, nor allows for the use of the most up-to-date information, and it's not reflective of national guidance. Now, it's important to note that this matter has already been determined by an inspector dealing with this very district. In the floor appeal, the inspector was presented with the same alternative positions in broad terms as occur at this inquiry, and concluded that a single district-wide figure should be used, and that the suggestion that was made in that case of there being a Daventry policy area and approaching the matter on that basis was incorrect. Very important, that's been determined. The only response the appellants provide to this clear decision is to suggest that the specific points that they now raise were not argued before that inspector. Well, with respect, that's nothing to the point. It's clear that the inspector appreciated that a choice had to be made and a clear decision was taken. It's entirely obvious, we say, that the inspector would be required to consider this issue in any event, and therefore the fact that any particular argument was not directed to it cannot direct from the force of the conclusion that the inspector reached. Moreover, the decision is clearly correct for two principal reasons. First, the appellant's approach has to be based upon a convoluted approach to obtaining information, that was with respect to the dwelling stock, which cannot now be directly obtained from published sources on a what I've called a previous area basis, on the basis of the three areas. And secondly, the approach isn't supported, contrary to what Mr. Tiley said, by national policy. PPG paragraph 16 suggests that previous strategic housing requirement policies can only continue to be used in the areas they apply to, where they are less than 5 years old, typo there, or have been reviewed within the last 5 years. And of course, neither appears, neither case applies here. Instead, the important words of the paragraph are these: that where policies are more than 5 years old, local housing needs should be used where this is available. Where the data required to calculate local housing need is not available, an alternative approach will need to be used. Now, in this case, the local housing data is available, but it's available on a district-wide basis. And as such, there is no justification for using some other basis of calculation on the previous area basis. Addressing the words of the paragraph, no alternative approach is called for. And as such, the district-wide figure is clearly the appropriate one to assess. The individual sites, there's a couple of points I want to deal with. Firstly, it was suggested on a number of occasions that the council had adopted the wrong approach to category A and category B sites by virtue of the fact that the council said, with respect to some of the category B sites, that there was no evidence to suggest that they would come forward, and the leap was made by the appellants to suggesting that that meant the wrong approach had been carried out. Well, that criticism is incorrect. And it's important to recall what the actual policy guidance is. And the only requirement in the MPPF is that there must be clear evidence as to the ability of a site to bring forward units within the 5-year period. And then I've set out there and I've highlighted various passages of the guidance. I won't read it all because I'm sure it's something you're familiar with and it's a matter of record. But I do note, paragraph 25, that the guidance here is expressed in terms of examples and is an inclusionary list. And there's no specific further guidance on exactly how evidence is to be collected or assessed. That's a matter ultimately, sir, for you. And in those circumstances, it's entirely appropriate, even with respect to category B sites, to note that there is no evidence that sites will not come forward. That's all part of the factual matrix before you. But it's to be noted that in each case where this criticism was made, the council's evidence in the Scott schedule went on to add further information, clearly indicating that the council appreciated the position with respect to category B sites as set out in the NPPF glossary. So nothing in that point. The second general point is that Mr. Tiley adopted what I've described as a scorched earth approach to the inclusion of sites within the 5-year supply. I mean, his approach appeared to be that if there was any uncertainty or deficiency in the evidence, as he saw it, with respect to the delivery of units, then all the units which were expected to be coming forward from a particular site should simply be excluded from the supply. Fair to just pause and comment there that there were one or two sections where there were two sets of planning permissions, and Mr. Tiley, to give him his credit, accepted one planning permission, but where there were other permissions where there was some uncertainty, all of the units in that second planning permission would be excluded, and we say that that's not the correct approach. In reality, the reality is that where the delivery might not come forward at the rate which the council had originally suggested, there would nevertheless be some units coming forward within the 5-year period, and we say that that approach, just as really as a matter of example, was clearly displayed with respect to Bective Works, the Avenue Campus, and Western Road, and there were several others. Now, we submit that your role, sir, is to arrive at the best estimate you can on the basis of the evidence provided as to what the delivery of sites within 5 years would actually be. The approach of simply eliminating large number of units because they might not come forward as quickly as the council initially contended for is wholly inappropriate in that context. And we say so that you're well able to make an appropriate, reasonable estimate of how many units would come forward on a given site, even in circumstances where not all the units which the council expected would perhaps come forward. And therefore, in general terms, we say that when the evidence is considered in the sensible and pragmatic way which the guidance indicates, it's clear that the council's approach to the disputed sites is to be preferred. And on that basis, even when all reasonable concessions have been made, we still maintain a 5-year supply with a considerable margin, 630 odd units margin, for any further deductions. And therefore, we shouldn't be deemed out of date on the basis of the 5-year supply, as it were, simpliciter. So now we turn to the other grounds upon which the appellants assert that the tilted balance should apply. And as an introductory matter, obviously, these grounds only become relevant if we can demonstrate a 5-year supply. So all of these submissions I now make necessarily proceed on the basis that we have demonstrated a 5-year supply. Now, in considering these grounds, it's fundamentally important to note that the question to be answered, according to the wording of paragraph 11D, is whether the policies which are most important for determining the application are out of date. The policies are most important. And I noted the confirmation of that by Miss Butterfield under cross-examination. The often used shorthand, and it is a shorthand, of considering whether the development plan is out of date is not strictly accurate. The focus must solely be upon whether the most important policies for the determination of the particular application are out of date. Now, I'll deal first with the points of the age of the policy and the lack of review. We say it is well settled law that the age of policies is not sufficient of itself to render them out of date. There's ample case law for that proposition. I cite there, and I'll provide you with the Peel Investments case. If I may just add a note to that, sir. The position had been regarded as settled in the run-up to, if you remember, the Hopkins Holmes case in the House of, in the Supreme Court, forgive me. And then there was a brief remark by Lord Carnworth in that case, which seemed to suggest that age alone might, in fact, be capable of being a reason of itself. The importance of the citation of the Peel investment case is that that case post-dated Hopkins Holmes and considered the remark that Lord Carnworth had made decided it was obiter and restated the position that age of itself, even in policies which are so old that the whole plan is time expired, are not rendered out of date. And it's important again to note that Miss Butterfield accepted that age alone would not be sufficient to render policies out of date. And instead, she relied upon the requirement, both within paragraph 34 of the MPPF and within the 2012 regulations, that policies be subject to a review at least every 5 years. And of course, it's common ground that the last review of the policies was in 2020, some 5 years and 10 months ago. And as such, the strict requirements of review have not been met. However, once again, the mere fact of the absence of a review within the stated time can't be regarded as sufficient of itself to render policy out of date. It has to be noted that the case law suggesting that policies cannot be rendered out of date by age alone has developed since 2018. And here I pause to say that it was helpfully pointed out to me overnight that the appellants would remind you that in fact the regulations, which although dated 2012, in fact came into effect as an amendment in 2018. And so the broad point I put to Miss Butterfield that the policy had been in existence since 2012 wasn't strictly accurate, and one has to date the consideration of these matters to 2018. I take that point. I thank the appellants for the advance notice that it was going to be raised. But what I do say is that it doesn't change a jot in terms of the point that I make, the force of the point I make. The regulations and the requirements of review from 2018 have been in existence throughout the period during which the case law developed. And I refer specifically again to Peel, which is from 2021. And so all the time that case law has been developing to say that age alone is not a factor to render something out of date has also been buttressed by the requirements of review. And therefore, I say that also the absence of a review is of itself incapable of rendering policies out of date. So then we turn instead to what is required, which is as suggested in the opening sentences of paragraph 232, a consideration as to the extent to which the policies under consideration, and I remind you again, sir, it's the policies, whether those policies are consistent with the MPPF, and the focus on the policies, as the appellant itself was at pains to stress in Mr. Callis's cross-examination, is explicit from the wording of that of those first couple of sentences of para 232, which set out that the existing policies should not be considered out of date simply because they were adopted or made prior to the publication of this framework for those purposes referring to the 2024 reboot of the MPPF. Due weight should be given to them, that's the policies, according to their degree of consistency with this framework. And when you undertake that exercise, it's clear, we say, that the policies which are most important for determining the application are consistent with the NPPF and not out of date. As an introductory matter, it's necessary to deal with policy SA in the joint course strategy, because this assumed what I describe as a somewhat extraordinary prominence in the presentation of the appellant's case. Of course, can readily be accepted that the policy, which in fact, as you can tell, is an attempt to mirror the form of the old paragraph 14, it's clear that that's no longer consistent with the new wording of paragraph 11. But what the appellant entirely failed to demonstrate was that it was one of the policies which was most important for the determination of the application. if you look at the evidence, it's plain that neither the council nor Miss Butterfield considered it to be so. One is entitled to assume that those policies which are most important will be referred to when the substance of the application is considered. Those passages in the report to committees as the starting point, which consider the principle of the development, do not mention policy SA at all. There's only the briefest of references to it in the consideration of the planning balance in section 9 of the report. And if there's any doubt about that, Mr. Callis, in his proof, identified the key policies in paragraph 7.6 of his proof. And even he drew a contrast, if you look at his paragraph 7.5, between relevant policies and key policies. Of course, when he identified the key policies, policy SA is not referred to there. And I have to note that whilst Mr. Callis was challenged in his cross-examination as to the consistency of the policy, it was not suggested to him in that cross-examination that it was one of the most important policies for the determination of the application. And in fact, he confirmed in his re-examination that it was not. Now, this failure to attach importance to policy SA was shared by the appellants. Their statement of case set out at paragraph 5.7 those development policies which, quote, are considered of relevance to the determination of the appeal. And policy SA is not even identified therein as a relevant policy, let alone one of the most important. Likewise, in her proof of evidence, Miss Butterfield again failed to consider policy SA in her tables of development plan policy compliance, either in the full list or in the summary. And we say it is remarkable indeed that a policy now asserted to be amongst the most important for the determination of the application is not even regarded as worthy of consideration in that exercise. And frankly, sir, the attempt to clothe that policy in importance in Miss Butterfield's re-examination was clearly a self-serving exercise, wholly at variance, frankly, with the position adopted by the appellants in all their previous materials. And therefore, the inconsistency of policy SA with the new NPPF paragraph 11 is entirely irrelevant to the issue of whether or not the tilted balance should apply. So then we do turn to those policies which are of greatest importance. And when you do so, they are consistent with the NPPF. As Miss Butterfield accepted, the fundamental purpose of the NPPF is to bring about sustainable development. And the central mechanism of the Joint Core Strategy for bringing about a sustainable pattern of development, which carries down, in fact, to the policies in the South Northamptonshire Plan, is the tiered hierarchy based around first Northampton, then Daventry, then Towcester and Brackley, and thereafter the rural areas. And that's contained within policy S1 and necessarily supported by the policy of restraint in rural areas, which is contained in policy R1. And you'll recall, sir, that they are the policies which are primarily considered and referred to in the report to committee and the evidence. And these, and fundamentally important, these are policies which remain capable of bringing about a sustainable pattern of development, even when higher housing numbers are called for. As Miss Butterfield herself recorded in her proof, she says this: the appellant considers that the spatial hierarchy for development remains relevant and appropriate as it directs development towards a number of sustainable locations, including Brackley, across the plan area. Now, she does, to be fair, thereafter in her proof seek to assert that the expansion of the Mercedes headquarters in Brackley rendered the hierarchy out of date. But that, we say, sir, is entirely flawed. We have information in CDs as to the scale of the expansion, and it's by no means huge, 1,400 to 1,900 jobs. And moreover, the council, in preparing its now superseded Regulation 18 consultation local plan explicitly recognised that the expansion was to occur, but as set out in the proposed policy S1, the spatial hierarchy was undisturbed by that change. And indeed, Miss Butterfield conceded, rather than being a matter which rendered the spatial strategy out of date, the proposed expansion was, and these are her words which I noted carefully at the time, and I quote directly, a factor to take into consideration in the preparation of a new plan. It's a very long way away from something rendering the existing strategy out of date. And we say, as such, policy S1 remains capable of directing development to sustainable locations entirely in accordance with the fundamental objectives of the MPPF. The spatial strategy and the consequential locational policies of the plan, R1, which are properly to be regarded as the policies most important for the determination of the application, they are entirely consistent with the MPPF and thus are not out of date. Now, in this context, it's convenient to deal with the appellant's broader argument concerning the consequences of the fact that the council has, as a result of local government reorganisation and the consequent availability of data sources, which I've already addressed, moved to monitoring its 5-year supply on a district-wide basis, rather than with respect to the 3 individual areas which now make up the district. It is suggested that this change necessarily has the consequence that the spatial strategy has been abandoned. Well, we say that that suggestion is entirely wrong. There is manifestly a difference between how the 5-year supply is calculated and counted and the way in which the development is distributed. As accepted by Ms. Butterfield, as I've already submitted, policy S1 remains capable of directing development in a sustainable manner, even when the number of units to be so directed has increased. The fact that supply in one part of the district will count towards meeting need on a district-wide basis in a way which may not have been the case when calculations were undertaken on a 3-area basis, well, frankly, that's nothing to the point. The issue is whether or not some significant change is made purely by the change in a basis of calculation to the spatial distribution of the increased amount of housing which is to be provided. And there's simply no evidence before the inquiry to suggest that this was the case. To the contrary, as I've already submitted, the tiered hierarchy remains entirely valid as a basis for distributing development. And there is no question that the spatial strategy has been abandoned. It's just a non-point. Policy S3. Now, with respect to the increase in local housing needs since the December 2024 NPPF, and indeed earlier increases through revisions to the NPPF, it's accepted that the stated numbers in the adopted development plan do fall short of the local housing need, but that's not the relevant matter. Instead, the focus must be on whether or not this policy is amongst those most important for the determination of the application. Clearly, it's not. The policy S3 deals with the housing to be delivered primarily through allocations and with a small number of windfalls in the designated policy areas of the plan. It's of little relevance in determining the outcome of a large scheme outside the designated policy areas. The fact that the need for additional housing and the benefit therefore brought about by the provision of a significant amount of additional housing, the fact that that's capable of being a material consideration of sufficient weight to outweigh the policy of restraint of, forgive me, that should say R1, policy R1, demonstrates how little relevance the numerical provision in policy S3 are to the determination of this application. And furthermore, the mere fact that the new housing need is greater than the requirements in strategic policies is not sufficient of itself to render those policies out of date. And their policy, paragraph 232 of the NPPF expressly contemplates that policies will remain up to date where the LHN figure is greater than the housing requirements set out in strategic policies. Obviously, that's where, as we say is the case here, there's a 5-year supply and the housing delivery tests are satisfied. And although the paragraph includes a time constraint, which I'll come to in a moment, it's clear that the paragraph itself expressly contemplates that the increase in the local housing need figure need not render the policies out of date. It's all about, we say, whether or not there is a 5-year supply and the housing delivery tests are satisfied. We say they are. We say that means that the policies are not out of date. And then 232, although it wasn't clearly articulated in the appellant's list of reasons, which I set out earlier, it's important to touch upon the fact that paragraph 232 indicates that policies will not be out of date in circumstances where there is a 5-year supply and the HDD tests are met, quotes, for a period of 5 years from the date of the plan's adoption. Now, insofar as it's suggested that a plan which is more than 5 years old cannot contain policies which are in date in those circumstances, this is to stretch the language of the paragraph too far. It's important to note that footnote 8, whilst directing attention to paragraph 232, does not explicitly include it in the list of those matters which automatically render policies out of date. This is in contrast to the fundamental matters of having a 5-year supply and meeting the HDD tests. Furthermore, the language of paragraph 232 itself does not suggest that policies in plans which are more than 5 years old will automatically be out of date. It simply provides that in circumstances, policies automatically will be in date. And it remains, as with all decisions as to whether policies are out of date, a matter of planning judgment, sir, for you. In this case, the fact that the policies are only narrowly beyond the period of 5 years specified in 232, together with the fact that the spatial strategy as a whole still provides an appropriate mechanism for distributing the higher numbers of housing, strongly suggests that the policies should remain in date, notwithstanding the fact that the numbers set out in S3 are less than those now required by the standard methodology. And finally, sir, in this section, whilst, as I've submitted, it's not accurate to describe the basic consideration as whether or not the development plan is out of date, it does remain the case that the plan policies are capable of bringing about sustainable patterns of delivery of the higher number of units now required to meet the local housing need. This is amply demonstrated by the fact that the plan is delivering a 5-year supply even against the local housing need figure and is meeting the housing delivery tests. Those two measures are the central drivers of the NPPF's policy to bring about a significant boost in housing numbers. And the fact that the plan is delivering in such manner, the fact that those two things are happening is a very strong indicator that the plan as a whole, if you look at it in those terms, remains consistent with the NPPF. Forgive me, sir, the proofreading of that paragraph seems to have wobbled slightly, and you see my dictation software in its full glory. I always say to people, if something looks funny in one of these texts, just imagine it being said in my estuarine wine, and you'll probably get the right answer. However, with all of that said, on that basis, we submit that there is no basis upon which the tilted balance should apply. The matter should be determined on a normal flat planning balance. If we're wrong about that and the tilted balance applies, we certainly agree that the harm does not significantly and demonstrably outweigh the benefits, and permission should be granted. And so accordingly, sir, the council, we submit that planning permission ought to be granted. This is on the basis of a flat planning balance where breaches of development plan policy are outweighed by the benefits of the scheme, such that material considerations indicate that planning permission should be granted. And so, unless I can assist you further, those are my closing submissions in this matter.
Thank you ever so much, Mr. Fraser-Urquhart. I think you were struggling a little bit with your voice through some of that. I hope you're going to be all right for your holiday.
We'll be fine.
I'm
10
sure
hours
you
of
will
plain
be.
drinking will do wonders for that.
All right. The only thing that arises from that, and thank you for that, as I say, I'm going to record that as inquiry document 14. No,
Yes,
sorry,
sir.
not 14. Bear me 1 second. It's inquiry
15.
document 15. The only thing that arises is a copy of the appeal judgment,
Yes.
which you can submit sometime in the next few days. But I'll confirm that in an email probably this afternoon of the things that we need to just wrap up, including the timescales. But thank you for
I'll
your
get that
contribution.
organised. Thank you, sir.
Thank you for your contribution. Perhaps if you wish to turn your camera off, you'll only need to come back in. I think Mr. White's completed his closing submissions. In which case, can we move straight toward Mr. White? There's nothing more I think that I need to say, unless you want to, by way of an introduction to material that I might need to think about, or you are going to submit. You can give me a pre-gambit on that, but if not, you can proceed directly to your closing submissions.
Thank you, sir. You'll be pleased to note the approach I take, and it's endorsed by the Lord, not the Lord, the Lady Chief Justice, is to share the burden with one's junior. And I intend to ask Miss Sear to read a bit out. And I'm sure not only, well, frankly, it will save you listening to the monotony of my voice for half an hour. I assume, sir, through your comments that you've received from Mr. Salter our closing. You've got it in front of you.
I've got your closing. I've also got 3 cases: Gladman Developments, Daventry District Council, the Wayne Homes, which I think is a core document, and Telford and Meakin.
It's not, sir. It fails. Wayne Homes were litigious in the previous past, and there were 2 cases involving.
Right. It's not E21 then.
Yeah.
So can I just say, I don't think I've received a copy of
You have
the White closing.
Well, I did check that. It was my learned junior did send 10/11, including your
It's
email.
now just, forgive me, it's now just popped up in, oh, is it?
Yeah, you see, Francis Taylor Building puts all landmark emails into spam or junk, does it?
I would imagine quite justifiably so. I've now found it. Thank you very much. Apologies for that.
You have it. Do you have it?
Yes, I do, sir. Thank you.
In which case, the 3 cases that you've referred to, do you have also the cases that's been referred to as well in that email?
Yes.
So yes, they were kindly provided to me last night. So
okay.
yes, I do.
Once you've completed your closings, Mr. White, I'll give those inquiry document numbers, which I think just remains appeal case and to be added to that list.
That's right, sir. Great.
Right.
Well, I will then commence. And before I do, though, my learned friend very correctly thanked you yesterday for your approach. And of course, on behalf of the appellants, I must commend and endorse those sentiments, because it's been delightful doing an inquiry that has been, from everybody's participation, friendly, constructive, and frankly, without any rancour. So, and that's largely been led by your approach, sir. So I thank you for that on behalf of the appellants formally.
Thank you very much indeed. I appreciate those comments, but it equally applies to everyone who participated, I think. But I'll leave it at that. Thank you.
Thank you, sir. So can I go to the closing submissions? And as we said in opening, and I think we've all reflected on this, this has been the most unusual appeal. We find ourselves closing the inquiry on the behalf of the appellants as we've begun, in the happy position whereby both parties agree that planning permission should be granted at the conclusion of this appeal. And the evidence that you've heard this week has confirmed that that must be the right outcome for the following reasons. The appeal scheme will provide 700 new homes against the backdrop of a national housing crisis and a clear local need. 40% of those will be affordable. Secondly, there'll be a wealth of other important benefits, including public open space, the proposed 0.5 hectares of allotments, the rugby pitch, economic benefits and environmental benefits. Those new homes and the benefits that are to be delivered in what is agreed to be a highly sustainable location with access to an abundance of established services and facilities via sustainable transport methods. The cumulative benefits of the scheme are agreed to be very weighty, whether you take, as I put in the footnote, substantial per Mr. Callis or very significant per Miss Butterfield. Neither sought to argue that there was a material difference between those two terms. By contrast, the scheme's impacts are agreed to be limited, and it is noticeable that a scheme of this scale on a greenfield site, there were no outstanding technical or environmental objections to planning permission being granted after more than 4 years of intense scrutiny and consideration by the LPA. There was also a remarkably limited level of third-party objections to this matter, and indeed one member of the public, Mr. Blenko, took the time to come and speak in support of the proposals. Those objections which were raised by third parties at the inquiry have been addressed in the appellant's evidence. The accepted breach of the development plan through development outside the settlement boundaries is agreed to be outweighed by other material considerations. That is so even taking the council's case at its highest and giving full weight to the development plan and applying a flat planning balance. We also say to you, sir, the proposal will be delivered. There is no legal impediment to the implementation of any planning permission that you may choose to grant, which would preclude the delivery of the benefits outlined. In short, sir, at the close of the inquiry, there is ample undisputed evidence before you which strongly supports the grant of consent for the appeal proposals. However, we say that the case for granting permission is even stronger than this because it is overwhelming in that the most important development plan policies for determining the application are very clearly out of date for a whole range of reasons which we'll come on to. The consequence of that, of course, is that the appeal falls to be determined on the tilted balance, whereby permission is to be granted unless the adverse impacts of doing so would significantly and demonstrably outweigh the benefits. The council, of course, agree that the case for granting planning permission is even stronger if the tilted balance is applied. The remainder of these submissions are structured as follows, sir. We're going to deal with whether the proposal complies with the development plan. Then if you take the view the tilted balance is engaged, can the council demonstrate a 5-year housing land supply? Is the development plan out of date regardless of the 5-year housing land supply position? And then to conclude on the overall planning balance. So dealing shortly with whether the proposal comply with the development plan, agreement is what it comprises, and both planning witnesses agree that the proposal would breach a number of planning of the development plan policies as a result of the location of this proposal outside the defined settlement boundary. They also agree as a result, overall, there is non-compliance with the development plan taken as a whole. However, the witnesses also agree in their judgment other material considerations indicate that permission should be granted despite this non-compliance. It is fundamental and intentional. And so I just ask you to reflect on this. We often forget this, but the intention of the statutory provisions in terms is that it is permissive and lawful for other material considerations to outweigh a potential conflict with the development plan. There is no dispute that such a decision is completely within the legal tramlines set out by the statutory duty. Consequently, the appellants say the grant of permission in this appeal would fully accord with the parameters and contents of Section 38(6) of the Planning and Compulsory Purchase Act 2004. This is regardless of whether or not you conclude that the most important policies for determining the application are out of date, as evidenced by the fact that even when Mr. Callis affords full weight to the policies, he concludes that planning permission should still be granted. So now I'll ask Ms. Thea to take up the reading of the speech. Is the tilted balance engaged?
Thank you. So turning then to the question of whether the development plan is out of date such that the tilted balance is engaged. We're of course very familiar now with the language of Para 11D of the MPPF. The critical wording for present purposes is where the policies which are most important for determining the application are out of date. That is the wording which, in the absence of footnote 7 policies providing a strong reason for refusal, which the parties agree is not the case here, triggers the tilted balance in Para D2. There is no dispute between the parties that if the council cannot demonstrate a 5-year supply of deliverable housing sites, the most important policies are deemed out of date by footnote 8. The appellant's position is that based on the evidence of Mr. Tiley and the discussions of the roundtable session, the council cannot demonstrate such a supply, as we discuss in more detail below. However, even if you conclude that the council can demonstrate a 5-year housing land supply, the appellant's case is that the most important policies are out of date for at least 5 additional reasons, which we also expand upon later. Starting then with whether the council can demonstrate a 5-year housing land supply, 3 issues remain in dispute between the parties at the close of the inquiry. Firstly, the area of assessment. Second, the way in which local housing need is to be calculated. And thirdly, the deliverable supply itself. So taking each of those in turn, and starting with the area of assessment, it's agreed between the parties that the development plan requires housing land supply to be monitored on a disaggregated basis for each of the sub-areas which make up West Northamptonshire. The relevant sub-area for present purposes being South Northamptonshire, excluding the NRDA. 5-year housing land supply should be assessed for that area unless material considerations indicate otherwise. Material considerations, of course, include the government's planning practice guidance on housing supply and delivery. Mr. Tiley drew your attention to the following passages within that guidance. Firstly, that for councils with a joint plan, such as the council here, the area of assessment is to be established through the plan-making process and will need to be set out in the strategic policies. Following local reorganisation, as has happened here, planning policies adopted by predecessor authorities will remain part of a development plan until they are replaced by adopted successor authority policies or until the 5th anniversary of reorganisation, neither of which is the case here. Where the strategic housing requirement policies covering the predecessor authority area are more than 5 years old and require updating, as is the case here, local housing needs should be used where this is available, or an alternative approach will have to be used. Accordingly, the PPG expressly supports Mr. Tiley's position that the continued use of South Northamptonshire, excluding the NRDA, is the correct area of assessment. It became clear at the roundtable session that Mr. Wood's contention that the correct area of assessment is West Northamptonshire as a whole, contrary to the development plan, is entirely premised on only a partial reading of the following passage in the PPG. Where strategic housing requirement policies covering the predecessor authority area are older than 5 years and require updating, local housing needs should be used where this is available. Where the data required to calculate local housing need is not available, an alternative approach will have to be used. He considers that, because the standard method local housing need data is only available for West Northamptonshire as a whole, that is the correct area of assessment. This ignores the second sentence, which requires one to assess using an alternative approach, just as Mr. Tiley has done. Consequently, the LPA's approach is contrary to national guidance. They have not pointed to any other material considerations to support their approach. Further, the LPA's approach has the following consequences. First, it assesses the currency of policies in South Northamptonshire based on the performance of different policies which apply in Daventry and Northampton. And second, as accepted by Mr. Callis in cross-examination, it means that it is not possible to gauge whether or not the spatial distribution required by policies S2, S3, S4 and S5 of the JCS is being achieved, and therefore whether a proposal accords with these policies. To put it simply, sir, the LPA's case on the area of assessment is entirely without merit for the following reasons. It is contrary to the statutory development plan, it is contrary to national guidance, it gives rise to perverse results, and it is implicitly predicated on the basis that the spatial distribution of policies S2, S3, S4 and S5 have been jettisoned, something which the Council robustly denies in arguing that these policies are up to date, which we'll come back to later. If you accept Mr. Tiley's evidence on this issue and take South Northamptonshire, excluding the NRDA, as the area of assessment, the position of the parties, based on their respective supply evidence, taking account of concessions made during the inquiry, are as follows. The LPA has a supply of 4.25 years, and the appellant says it has a supply of 33.89 years. So accordingly, even taking the Council's supply cases at its highest, it is unable to demonstrate a 5-year housing land supply if the correct area of assessment is applied. Alternatively, there was an indication by the Council at the round table that it is simply not possible to calculate housing land supply for the area of South Northamptonshire, excluding the NRDA. That is clearly wrong, given Mr. Tiley has been able to do so. However, it would also mean that the council is unable to demonstrate a 5-year housing land supply as required by the NPPF. So on either basis, the tilted balance would be triggered. As you heard again in Mr. Fraser-Acquar's closings, the council relies on the floor appeal decision to support the area of assessment they have used. You can see that at paragraph 17. The appellant's case remains that this decision is not determinative of the area of assessment point, which was not in dispute before the inspector in that appeal. In any event, that decision is of course not binding on you, sir, and you will have to reach your own conclusion based on the evidence and arguments that you have heard at this inquiry. Turning then to the calculation of local housing need. The parties agree that because the adopted policies are more than 5 years old, the 5-year housing land supply should be calculated against the local housing need in accordance with para 78 of the NPPF. If you conclude that supply is to be assessed for South Northamptonshire excluding the NRDA, the only evidence of a local housing need figure before you is that of Mr. Tiley. His figure is 469 homes per annum with a 5% buffer, leading to a total of 2,528 homes over the 5-year period. That figure has not been challenged by the council. If, contrary to the appellant's case, you conclude that the area of assessment is West Northamptonshire, the parties agree that the standard method should be used. There is, however, a dispute as to one of the inputs into that calculation. Mr. Tiley uses the most recent affordability ratios showing the position for 2024 as published in March 2025 and the most recent housing stock information, also reflecting the position in 2024 and published in May 2025. Mr. Wood uses the same affordability ratios, but outdated housing stock information reflecting the position in 2023. The LPA's approach is, once more, directly contrary to national guidance. The PPG on housing and economic needs assessment states quite clearly that the standard method is to be calculated using the most recent data published at the time. The justification for this, provided by Mr. Wood at the round table, is that it would be impractical to take account of new information to feed into the HLS assessment as and when it arises. This argument is flawed for a number of reasons. The Council's HLS assessment was published in June 2025 and therefore post-dates the latest housing stock information from May 2025. Second, the LPA has repeatedly at this inquiry relied upon newly arising information in respect of its supply, as is evident from the production of ID 6 and ID 13. The latter document confirms that the statements of common ground upon which the LPA rely were agreed in April, May, and June 2025. It is inconsistent not to take account of new information affecting the requirement in the same way. It gives rise to a disconnect. Thirdly, this approach gives rise to a disconnect between the period reflected by the affordability ratios from 2024 and the housing stock data from 2023, and an increased disconnect between the housing stock data and the period of assessment, which is of course 2025 to 2030. If you calculate the LHN using the most up-to-date inputs in accordance with national guidance, the parties agree that the requirement for West Northamptonshire, including a 5% buffer, is 13,273 homes over the 5-year period. Turning then to the deliverable supply itself. The NPPF glossary defines deliverable sites as those which are available now, offer a suitable location for development now, and are achievable with a realistic prospect that housing will be delivered on the site within 5 years. It also sets out that sites with outline planning permission for major development, allocated sites, sites with a grant of permission in principle, and sites identified on a brownfield land register, known as Category B sites, should only be considered deliverable where there is clear evidence that completions will begin on site within 5 years. The LPA's assessment of its deliverable supply departs from national policy, guidance, and case law in numerous regards, which are set out in detail in Appendix 2 to Mr. Tiley's brief, and his comments on the Scott schedule appended to the Housing Statement of Common Ground. That is not a scorched earth approach, as the LPA indicating in its closing submissions, but a correct attempt to marry up the supply claimed with the requirements and parameters of government policy in the NPPG, which is highly pertinent in judging such matters. The simple point, apologies for the typo, is that the LPA misapply or are deeply casual in assessing deliverability because of their desperation to show a 5-year housing land supply. These fundamental errors lead to Mr. Tiley's conclusion, as set out in ID 6, that the Council can only demonstrate a supply of 3.89 years for South Northamptonshire, excluding the NRDA, or 3.84 years for West Northamptonshire as a whole. In the interest of time, we will not go through the deliverability of every individual site which remains in dispute between the parties. However, it became apparent following the roundtable session that the LPA's case on a number of larger sites, including but not limited to those set out in the polling table, was without any credible justification. And those sites are site number 5, the Northampton Railway Station car park, which accounts for 280 of the homes in dispute. And it is entirely unrealistic to suggest that this site could achieve any completions within 5 years, given that 1, it is phase 2 of a development and neither it nor phase 1 benefits from planning permission. 2, committee members have recently raised significant concerns with the current planning application, leading to consideration being deferred. 3, even if planning permission were granted, it would require an unprecedented lead-in time to achieve any completions within the 5-year period, given the proposal is for a single 280-unit block of apartments, as you pointed out, sir. And 4, ID 13 shows that the statement of common ground relied upon by the Council was signed by Network Rail, the landowner, not a developer, and without any direct experience of the amount of time it takes to implement residential developments. The second site we draw your attention to is number 6, the Northampton Railway Station rail freight, which accounts for 186 dwellings within the supply. And this is phase 3 of a development that I've just spoken about. And consequently, it is even less realistic that it will achieve any completions within the 5-year period. Further, that site is not available for development now because it is currently operating as a rail freight facility, which is a clear impediment to the immediate development of the site beyond the absence of planning permission. The LPA provided no response to that point during the roundtable session. Further still, as with the site above, the statement of common ground was signed by Network Rail, not a developer. The next site we'd draw your attention to is number 45, which accounts for 170 units. And the LPA accepts that the permitted schemes in relation to this site are no longer viable, and that in order to progress a revised scheme, there is a need for 2 land disposals, 2 infrastructure contracts, a new planning application, and a new electricity supply to the site, which is not anticipated before October 2028. The scale of any new application is also unknown. Mr. Munn therefore quite rightly accepted, when questioned by you, sir, that there is a lot that needs to happen in order for completions on this site to be realistic. Further, there is no evidence, let alone clear evidence, that any completions will be achieved within the 5-year period. The next site is number 50, the N4 Northampton West Phase 5, which accounts for 100 homes. And this is one of the sites being developed by Davidsons, who are, of course, one of the appellants to this appeal. And the LPA is relying on a statement of common ground signed by Ms. Keegan, Senior Planning Manager of Davidsons, to support the delivery of 200 homes on the site within the 5-year period. Mr. Tiley's evidence, which was confirmed by Ms. Keegan, is that there is an obvious error in the statement of common ground in that it anticipated house building commencing in the same quarter as the approval of hybrid planning permission and prior to groundworks and initial infrastructure. And 2, in any event, the statement of common ground has been superseded by significant delays, which include deferral of the application by committee, delay in agreeing with Section 106, and waiting for a footpath diversion to be approved. This has resulted in a change in the estimated delivery figures set out in the Statement of Common Ground signed in May. The next site we'd ask you to have regard to is number 53, N9A, and specifically the Norwood Farm portion of this site, which accounts for 697 homes. And there are 2 critical issues with the LPA's assessment of this site. And the part of the site to which these deliveries relate does not yet have planning permission some 4.5 years after the application was made. That's the first point. The second is that there is no evidence, let alone clear evidence, that completions will be achieved within the 5 years, and the council here has applied the wrong test, requiring the appellant to provide evidence that completions will not be achieved. And the third point is that the LPA have assumed an unprecedented and unrealistic build-out rate of 295 homes per annum when compared against historic delivery in West Northamptonshire on similarly sized sites of 188 homes per annum. Next is site 54, east of Wootton Fields, which accounts for 150 dwellings. This is an emerging allocation, which does not fall within Category A or Category B of the MPPF definition. The inclusion of such sites is precluded by the PPG on housing supply and delivery, as repeatedly confirmed in a number of appeal decisions, which I've provided there in the footnote. The LPA provided no response to this point during the roundtable session. Further, the statement of common ground relied upon by the council appears to have been provided by a land promoter, not a developer, who will not be able to accurately predict how long it will take to deliver completions. Next is site 56 of Daventry North East, accounting for 350 homes. This site is also being developed by Davidson's, and they have confirmed the site will deliver materially fewer homes than estimated in the statement of common ground relied upon by the council, signed in May 2025. And that is due to the LEA requesting revisions to the proposal, which will require lots more work, including an addendum to the environmental statement and a revised viability assessment. Mr. Wood alleged at the roundtable session that Davidson's was somehow at fault for the delays in the determination of its application. As you heard, sir, this was strongly denied by Ms. Keegan on behalf of Davidson's, who explained that the main delay was due to awaiting a draft PPA from the council. The penultimate site that we'd ask you to have particular regard to is number 57, accounting for 86 homes, and that is the site, you'll recall, sir, in respect of which none of the very many pre-commencement conditions have been discharged prior to expiry of the permission. Any delivery pursuant to that permission would therefore be unauthorised development, and there is no evidence of a new application coming forwards. And you made your views on that site quite clear, sir. Finally then, site 59, north and west of town centre Daventry, accounting for 60 homes, the LPA here acknowledged that there was no evidence whatsoever as would be necessary to conclude that this site is deliverable. Those sites alone account for 2,079 homes within the council's allegedly deliverable supply. The parties' respective positions at the close of the inquiry are set out in the table that I put there, and I won't go through all the numbers, but in short, Mr. Tiley's position is that the council can demonstrate a supply of 3.89 years on the correct area of assessment for South Northamptonshire, and the council's position is that it can demonstrate 5.29 years against the West Northamptonshire area of assessment, with a surplus of just 768 homes. Accepting Mr. Tiley's evidence on just the 9 disputed sites set out in the table that I've been through would result in reducing the council's housing land supply by 2,079 homes, bringing them very clearly below 5 years, regardless of the area of assessment or inputs into the local housing need requirement. The evidence of Mr. Tiley is to be preferred. He alone took an approach consistent and cognizant of what deliverability actually means in the context of national guidance and the MPPG. Unfortunately, Mr. Wood's evidence was characterised by an inability to ever concede anything, however unrealistic or unreasonable his position was. In contrast, Mr. Tiley readily accepted evidence, and it had the consequence of changing his position at the inquiry. By contrast, Mr. Wood made there were very limited concessions made, I think, within the roundtable session for a very small number of sites, and was unwilling to concede anything, even when pressed by you during the roundtable session in relation to the larger sites. So concluding then on housing land supply, in conclusion, it is very clear that the council cannot demonstrate a 5-year supply of deliverable housing sites, and consequently that the most important policies for determining the application are out of date, applying footnote 8 of the MPPF. And at that point, I will hand back to Mr. White to finish the closing submissions.
Thank you very much. So the next issue, therefore, you need to address as are the most important policies out of date, regardless of your conclusions on HLS. And Mr. Callis agreed, you'll recall, during his cross-examination that footnote 8 of the NPPF is not exclusive. In other words, it's not the case that failure to demonstrate a 5-year housing land supply is the only means by which the most important policies for determining an application can be rendered out of date. That is clear from the language of footnote 8 itself. This includes, it states at the start, and see also para 232 at the end. It's also been confirmed in the Gladman case in the High Court. It is our case that the most important policies are out of date for the following 5 reasons. Firstly, the failure to carry out a review. Secondly, the inconsistency of the proposals of the policies with the NPPF. Thirdly, the significant increase in local housing need following adoption of the standard method in December 24. Fourthly, the Council's decision to assess housing land supply on an aggregated basis. And fifthly, the Council's agreement that permission ought to be granted in this case. Taking each of those in turn, the first of all is the failure to do a review. And as we've set out, sir, Regulation 10A, and I don't need to read it out, but it was inserted in 2017, and my learned friend's very gracious acceptance of the point that it was actually brought in on the 6th of April 2018. It provides in the clearest terms that in respect of a local plan, the review must be completed every 5 years. That legal requirement is also in the NPPF in para 34, again saying that they should be reviewed as to whether they need updating every 5 years. And it also continues that the relevant strategic policies will need updating at least once every 5 years. The Council agrees that the Joint Core Strategy has not been reviewed in the last 5 years in accordance with para 34 of the NPPF, and the local housing need under the standard method is significantly in excess of the figure in the JCS. The Council's admitted failure to comply with the legal requirement imposed by both the regs and para 34 cannot frankly be inconsequential. In our submission, the effect of non-compliance is clear. The policies which have not been subject to a review are out of date until a review is carried out which concludes that they do not need updating. The Council rely on the case of Peel Investments to support a proposition that policies being more than 5 years old does not automatically render them out of date for the purposes of a para 11D. That paragraph of relevance in the judgment states there's nothing in para 11D in the 2018 NPPF or its predecessor, paragraph 14, to suggest that the expiry of the plan automatically renders the policy and the plan out of date. However, there's no reference to that judgment to the then para 33 of the 2018 NPPF, now of course para 34, which dealt with the need to review plans every 5 years under the 2012 regulations. The basic point, so, is it doesn't appear to have been considered by the High Court in that case. We have not been able to identify any case law which says that the policies which are not rendered out of date for the purposes of para 11 by reason of not having been reviewed in accordance with Regulation 10A, nor has my learned friend. We are well aware of the case law which says that the age of plan policies alone does not mean that they cease to be part of the development plan, nor that they lose the priority afforded development plan policies by section 38(6). The Council, of course, is right to say that weight to be attributed to policies which are more than 5 years old is to be determined in accordance with its consistency with the NPPF. That is clear from para 232. However, the question of weight attributable to policies that are more than 5 years old is distinct from the question of whether those policies are out of date for the purposes of para 11. In any event, sir, it's not our case that age alone has rendered the most relevant policies out of date here, because, of course, we rely on the 4 further reasons which I'll now deal with. In addition, of course, to our primary case that the Council was unable to demonstrate a 5-year HLS. Secondly, inconsistency with the NPPF. Now, this debate, sir, has been materially changed in our submission by the acceptance or concession in the LPA's closing at para 38, where it's now accepted for the first time in terms that the overarching sustainability policy in the core strategy, policy SA, is said to be no longer consistent with the new wording of para 11 of the NPPF. We say this is a game changer, and it's not open, frankly, to the Council to continue to contend that the plan is up to date when it now accepts its overarching policy dealing with sustainability and the policy which seeks to incorporate para 11 into the development plan is accepted to be inconsistent with the NPPF. prior to this momentous concession, the council's continually asserted that where an LPA can demonstrate a 5-year housing land supply, policies can be found to be out of date if they are inconsistent, can only be found to be out of date if they are inconsistent with the NPPF. That is wrong, of course, for the reasons we have set out. But even assuming they are right, the most important policies here are fundamentally inconsistent with the latest version of the NPPF. As Mr. Callis accepted in cross-examination, policy SA is seeking to replicate Power 11 of the NPPF as it was when it was adopted, i.e. in 2012. And as you know, sir, there have been numerous revisions of the NPPF since that date, including material changes to Power 11. Mr. Callis's attempts to suggest that these changes were immaterial is frankly untenable. As Miss Butterfield explained in her evidence, these changes were made intentionally by the government to limit the circumstances in which the tilted balance would be disengaged. Mr. Fraser-Urquhart's remarkable response to this was to suggest, and it developed in his closing, that policy SA, which sets out the overarching framework for planning decisions within the joint core strategy, is not one of the most important policies for determining the application. It's noteworthy, and this is a point relied on in closing, that Mr. Callis has not included it as a key policy. There was no formal assertion in his examination in chief that in his judgment the policy SA was not a most important policy. In any event, sir, what evidence you have heard doesn't matter, because the question is for you. And the fundamental point here is whatever Mr. Callis tries to argue, we ask you to appraise your judgment. If the intention of that policy was and is to implement the presumption in favour of the sustainable development and to incorporate the tilted balance into the development plan, which of course is of critical importance, particularly in the context of a proposal of this magnitude and scale. We say, I'm afraid, it is a novel, indeed frankly preposterous argument deployed solely in expediency to argue that the most important seminal and central policy in the core strategy is not somehow a most important policy. The third reason we say the development plan is out of date is because of the significant increase in local housing need following adoption of the standard method. On a broader level, the policies in the extant development plan, including those which are most important for determining the application, are inconsistent with the NPPF and therefore out of date because, of course, they set out a housing needs figure that's significantly below the calculation produced by the standard method. The development plan therefore fails to provide for the objectively assessed housing needs as a minimum as required by Para 11B, or secondly, provide a framework for meeting housing needs as an up-to-date plans are required to do by Para 15, or thirdly, to make sufficient provision for homes in accordance with Para 20A, or fourthly, provide a clear strategy for bringing sufficient land forward at a sufficient rate to address objectively assessed need over the plan period per Para 23, or ensure that a sufficient number and range of homes can be provided to meet the needs of present and future generations in accordance with Para 8B. That is confirmed by the second part of Para 232 of the NPPF, and I won't read that out, sir, as that's probably after this inquiry ingrained on your memory bank. Therefore, assuming, contrary to the appellant's case above, that the LPA can demonstrate a 5-year housing land supply, we agree with the council that the LHN is greater than the housing requirements set out in adopted strategic policies. We also agree that it's more than 5 years from the date of the plan's adoption. Therefore, we say the policies here are not saved by this part of the NPPF. Accordingly, and as Mr. Callis agreed in his case officer's report before changing his position at this inquiry, it can consequently be inferred that policies adopted more than 5 years ago will be out of date. The report does subsequently seek to get around this entirely logical and common sense inference by saying that Para 232 is essentially inapplicable because this LPA can demonstrate a 5-year housing land supply against the LHN, and therefore the fundamental requirement for being in date is satisfied even with respect to the new LHN. However, that argument is entirely circular because this part of Para 232 only applies in circumstances where LPA can demonstrate a 5-year housing land supply. And secondly, in any event, it's simply wrong to say that the fundamental requirement for being in date is having a 5-year housing land supply. As we've set out above, that is only one means of triggering the presumption. Fourthly, why we say it's out of date is, of course, the council's decision to go to the aggregated basis. As Mr. Tiley's evidence explains, every housing land supply prior to June 25 has adopted the approach of calculating land supply on a disaggregated basis, in line with the expectations of the development plan. The change in position of June 25 is to totally disregard the spatial strategy of policies S1, S3 and S4 of the Joint Core Strategy when assessing 5-year housing land supply. It is fundamentally inconsistent for the Council to adopt this approach in calculating supply whilst insisting that the spatial strategy remains up to date. Further, as became clear during the cross-examination of Mr. Callis, the Council's approach makes it impossible for their own development case manager and officers, let alone a member of the public, to monitor implementation of spatial strategy policies such as S3 by reference to the published housing assessment. Of course, it required Mr. Wood, the head of policy at the LPA, to produce a bespoke note for you for the purposes of this inquiry, not previously available to the public, to explain how it could be done, namely ID 12. And even then, a tortuous, convoluted and problematical exercise has to be undertaken. That fundamental inconsistency between the development plan policy's distribution and the method of assessing completions was described in the case of Wayne Homes, the Northwest Limited, and the Secretary of State for Housing, Communities and Local Government as comparing apples with oranges. As Mr. Justice Dove in that case held, and the inspector's reasons were inadequate and they failed to grapple with and explain adequately her answer to the point raised in relation to the consequences for the distribution of housing set out in the core strategy for each of the central Lancashire authorities, upon which LP policy G3 depended, arising from her adoption of the housing requirement derived from the standard method for the purpose of taking a decision. The concessions made by the first defendant, that will of course be the Secretary of State on behalf of the inspector, were appropriate and the claimant must succeed on ground 5. Then fifthly, the Council's agreement that planning permission should be granted. As a matter of common sense, sir, you'll reflect, but the Council's agreement that planning permission ought to be granted in this case for significant development wholly outside of the settlement boundaries defined in the development plan must say something about its assessment of its ability to meet current needs within those boundaries. That in itself is indicative of important policies in the plan being out of date. And as Mrs. Justice Lang addressed in the Telford and Wrekin Borough Council decision, in her judgment, the inspector was entitled to have regard to other grants of permission in recent past in determining the question whether the policies on settlement boundaries were out of date. It was plainly a relevant consideration as it supported the contention that the current housing needs could not be adequately met within the settlement boundaries identified in the policies. The weight to be given to this consideration was a matter of planning judgment for the inspector, not this court. Therefore, sir, concluding on the tilted balance, we say there's now substantial evidence before you to find a conclusion that the most important policies are out of date, either by reason of the inability to demonstrate a 5-year housing land supply or for one of the additional 5 reasons that we've described above. Therefore, as a consequence of those various scenarios, we say the tilted balance is very clearly engaged. Therefore, turning to the application of the planning balance, we can deal with it fairly succinctly because there's so much agreement between the two principal parties in this appeal on the material inputs. We agree with the Council that the scheme will result in the following benefits and they should be attributed the following weightings, namely market housing, very significant weight, affordable housing, very significant weight, economic benefits, significant weight, environmental benefits, including BNG and allotments, limited weight, the provision of a rugby pitch, limited weight, the public open space, well in excess of policy requirements, significant weight, and seventhly, development in a sustainable location, significant weight. In addition, as you heard, Miss Butterfield concludes there is an 8th benefit, the high quality design, which she gives limited weight to it. Sir, a question was raised by you in terms of the enforceability of the provision of allotments and the rugby pitch under the 106 as drafted. With regard to the allotments, we take the view and have negotiated revised wording with the Council, which we say will overcome the concern. With regard to the rugby pitch, it has not been possible to agree a form of wording which ensures that in the event that Brackley do not take up the pitch, provided it will be offered to and taken up by another club. We therefore decided to revert to the original drafting of this provision. However, we say it won't impact your overall assessment of the benefits because both Mr. Callis and Miss Butterfield have given evidence on the basis that the 106 was drafted at the start of this inquiry, and that has not changed their attribution of limited weight to the provision of the rugby club as a benefit. Secondly, there's no evidence whatsoever that Brackley Rugby Football Club has any intention to refuse to take up the additional pitch which is being offered to them for £1. And thirdly, of course, in the overall planning benefits, this particular benefit is only afforded limited weight in any event in the context of 6 other benefits, 5 of which have got significant or very significant weight. Therefore, there was agreement that the cumulative benefits of the proposal are very weighty indeed, and we would commend you to endorse this assessment. Weighed against those benefits, whether on a tilted or flat balance, are 3 adverse impacts which Mr. Butterfield set out, which the parties agree should be afforded limited weight: conflict with the spatial strategy, localised landscape harm, and so, just to be absolutely accurate, temporary noise impacts arising in the construction phase of the development. That's a Butterfield impact. I don't think Mr. Callis identified it as such. But even so, Mr. Callis very rightly agrees that these impacts are outweighed by the benefits, even on his flat balance, and even giving full weight to the relevant development plan policies. He also agreed, unsurprisingly, that the conclusion would be even stronger if you were to apply the tilted balance. So in concluding, sir, you have before you at the end of this planning appeal only 2 comprehensive planning judgments, that of the LPA as expressed by Mr. Callis and that of the appellant as expressed by Miss Butterfield. In terms of the LPA, you can take great comfort that after 4.5 years, remember, of course, this is an application that was submitted in April 21, that the conclusion of the LPA in terms of the planning judgment of its officers in the planning officer's report of July 2025, in the statement of case submitted to this appeal proceedings, in the proof of evidence from Mr. Callis, and in the oral evidence yesterday, that planning permission should be granted, and is one reached after much consideration, reflection, and thought. We say that judgment deserves respect and material effect. In terms of the appellant, the case is that the cumulative benefits of the appeal proposal are very significant indeed, and very clearly outweigh the limited adverse impacts, regardless of whether a flat or tilted balance is applied. Nonetheless, the evidence has demonstrated that the most important development plan policies are very clearly out of date for the many reasons we have detailed. Accordingly, sir, we say the tilted balance is engaged. When that balance is considered, the position is even more stark. Evidently, the limited harms identified by the main parties do not significantly and demonstrably outweigh the overwhelming benefits of the proposals. And so, for those reasons, can I conclude the closing submissions of the appellant in this matter by urging you to allow the appeal upon reflection and consideration, and grant permission for this much needed and long awaited development to come forward. So, sir, those are the closing submissions of the appellant in this matter, unless we can help you in any other way.
Mr. White, Ms. Sayer, thank you very much for those closing submissions. Just before we bring Mr. Fraser-Urquhart back in regarding those legal authorities, I'll just give those a reference number for the avoidance of any doubt while it's in my mind. So if you just bear me 1 second, I'll go back to the email. And I'm going to do it in the order that they come into the email in my inbox. So the first case, the Gladman Developments versus Daventry District Council. I will give that a title of ID 17. The Wayne Holmes Secretary of State, the South Ribble Borough Council, I'll give that ID 18. And the Telford and Wrekin Secretary of State, Gladman Developments, that will be ID 19. So they've all been given a reference number there. I'll confirm that in an email this afternoon or later this morning. Going back now to procedural matters on that, put my computer back on. Mr. Fraser, you suggested you might want to make some submissions on those legal cases only.
Yes, sir.
Is there something you would like to say?
Yes, sir. There's just 2 very brief observations I'd like to make, if I may. Dealing first with the Wayne Holmes case on the distribution, the change from 3 areas to the single area, and the consequence that has. In my submission, if you examine paragraph 36 of the Wayne Holmes case, you will see there that there was a definite indication through evidence that the split in housing need was radically different in the core strategy approach and the local housing need approach. What I say in respect to that is that that is not the situation in this case. There's no evidence, I submit, that there is such a radical difference between the two, and the spatial strategy for distributing those higher numbers in my submission remains entirely valid, and therefore this case doesn't match the facts of our case such that it gives you any assistance. I then deal, if I may, again, just very briefly with the Telford case. Excuse me. Where I simply say that obviously you will note as a matter of fact that the decision was dealing with the ability to have regard to other grants of planning permission. That's not obviously the case here, but no doubt the principle is taken that it's what's said about the ability of the strategy to meet housing needs. And we say all that is suggested by the case is that it is a relevant consideration. And we say the fact that we choose to, or we take the view that the material considerations in this case indicate that the locational policies can be outweighed, does not tell you anything of any great relevance with respect to the decision you've got to make as to whether or not the most important policies are out of date. So that's all I have to say with respect to those two cases.
Thank you. Mr. White, is there anything there that you'd like to come back on?
So just briefly in relation to what my learned friend said, very, very simply in relation to waiting homes, we take the view that it does support the principle that you need to grapple with, that if there be a disconnect between a spatial strategy and the standard methodology, then it can render policies out of date. And that provides comfort for you to take the same approach here, that would be lawful. And at the very least, the point needs to be grappled with. In relation to Telford, just that the grant of planning permission can't be different to accepting it should be granted. That would be the point I stress for you. So those are the only two additional points, but obviously we ask you principally to reflect on what we say in the text as well. But thank you for giving me that opportunity.
Thank you, Mr. White. That concludes the closing submissions. The last bit of housekeeping then is just to perhaps go through some timescales. The only piece of information which, when we do receive it, which is appeal case, I'll record that as ID 20, but I will perhaps send an email to the parties to confirm I've received that and confirm those inquiry document numbers. I'm grateful for the early notification that there'll be no cost application. So the only matters that require now submission in relation to this inquiry is the revised list of conditions, the track change version of the section 106, so I can see what's been altered, and the completed 106. We had a little discussion yesterday. I can, well, let me reaffirm what my thinking is. I think we can give until the 14th of November for that revised list of conditions and the track change version of 106, and I'll go to the 21st of November for the completed version. Clearly, those are backstops and things may come in earlier than that, which will be welcomed. And I know there's parties here to sign the 106, but 3 weeks from today, I think should be adequate time. Obviously, if it can be done earlier, it can be done earlier, but if we can aim for those, I'd be most grateful. And I will confirm that in an email shortly, just to say that this is what we've agreed as a position for those 3 documents. So those are the only 3 documents now that I will permit to be submitted to this inquiry, other than the appeal case that we need as an inquiry document. And I'll confirm that in the email.
Yes, thank you, sir. I'll aim, obviously, because I wish to sort of clear my desk now. I'll aim to get that to you in the next few minutes.
No problem. I think that's then, it leaves me in a position to say that's the inquiry closed as far as oral submissions go, and written submissions beyond those documents which is identified, which I will confirm in the email. So I will, once I've received the final version of the 106, I will formally close in writing. From today, other than those documents that I've identified, there will be no further submissions that will be entertained in respect to this inquiry. The last thing I need to do is to thank everyone for their participation. It has been an unusual inquiry, but we spoke yesterday. It's been dealt with in the manner which was appropriate for the inquiry. I think it was dealt with in good heart. People were engaging throughout. The council's organisation was exemplary. Today, I was suspicious about whether or not the technology would work. That's perhaps my fearful of a Zoom that I've never done before, because everything we use is Teams, but it worked perfectly. So I think all that remains for me to say is thank you for your participation as a group. Mr. Fraser-Urquhart, I hope your cold gets better for your holiday, but in any event, enjoy your holiday. Mr. White, it's been good to meet you. I say good to meet you as well. I'm sure our paths at some stage in the future will cross again in some forum somewhere. But all that remains to me to say now is to thank you for your participation. And this call is now closed, and the inquiry in terms of further oral submission and written submission, beyond what I've already said, is closed as well. So thank you. Enjoy the rest of your day, if you can do so. I'll be Mr. Fraser-Urquhart. I suspect you've got a fairly busy afternoon coming up.
Yes, sir. Thank you very much indeed.
Thank you very much. I'm going to take myself away from the call. Thank you very much.
Thank you, sir.